Turner here. Charlie Masterbirdy. Charlie, I can barely hear you.
Here.
Better. Kelly Davis.
Here.
Rob Kwasnicki.
Here.
Kathy Plopper.
Here.
Rich Stroney.
Here.
I know that Andrew's coming on the call. I just spoke to him.
Hi, Marianne. It's Andrew.
Thank you, Andrew. Chairman, you have all of your folks here tonight. You don't need alternates.
Okay. I can't see everybody except for Marianne.
Well, that's good enough.
I don't know why. So, if Rob has his flag displayed, we'll do the Pledge of Allegiance. If not, we won't.
He does.
All right, let's stand for the pledge. I pledge allegiance
Allegiance
to the flag
the
of the
United
United States of America
and
and to the republic
To the
for
republic
which it
for which it stands,
one nation,
one
under
nation,
God,
under God,
indivisible,
indivisible,
with
liberty
liberty and justice
and
for all.
justice for all.
All right.
Lori, I can't see all the people on the call. Is it they're either not showing or I only can see so many?
If you have a 3 dots anywhere on your screen, you could go into that and try to go into gallery view. It seems to work for some and not others. I don't know why that is. I've actually got an IT ticket in for it.
I don't have anything that says gallery view. I have this thing that says turn off incoming video, but I don't know what that means.
That's all you have?
I have show device settings, show meeting details, enter full screen keypad, and turn off incoming video.
But you don't have the gallery or large gallery or together mode.
I don't
Yeah,
see
I'm not seeing it either.
I don't either.
Nor do I.
Did you guys download the app at all?
Yeah.
I have the app downloaded, yeah.
Yeah, that's what we've been discovering. Even if
Oh.
with the app downloaded, you're not able to see all the players, which is not supposed to be the way. So I really apologize, and we're trying to fix this. I don't like this platform at all personally, so I feel for you.
Yeah, all I see is first and last initials in a circle.
I can get to the participants by clicking on the little people and the names will come up on the right side, but I can't,
Correct.
if they're on video, I can't see them.
So right now I see 9 people on video. Everybody else has got their video off, which actually does help with the platform to run better. If you don't need to be on screen, you shouldn't be.
Okay.
So
Okay, Chairman, the ball's back in your court.
All right. We will start with the legal notice. Let's take the legal notices one at a time.
Okay.
We have quite a few of them.
All right. ZBA number 2021-0421 4 Hollywood Drive variance application to allow for a 4.5-foot side yard where 10 feet is required to allow a residential garage and breezeway addition. Michael Hahn, owner applicant, map 73, lot 37, R33 zone. The applicant's here, Mo.
Okay, will you state your name and address for the minute?
Yeah, Michael Hahn, 4 Hollywood Drive.
Okay. And go ahead with your application.
I'm looking for the variance for a non-conforming property line, 3.40.3, to reduce my side yard setback from roughly 5.2 feet to 4.5 for the corner of the garage, to square off the back corner of the garage to meet the back of the house.
Okay.
The property line goes on an angle from the front of the house, from the front of the property back, and it goes into the side of my property. An
Okay.
angle.
Rich, could you do me a favor, since you're very good at doing this? Could you put that up on the screen if you could?
Sure, just give me 1 minute. I'll pull it up.
Okay.
Mr. Hahn, where are you putting the second floor?
Yeah, it would be above the garage and breezeway.
Okay.
Question for you, sir. Just looking at the picture here, the current corner of the house is, you say 5.2 feet
Yes, roughly 5.2 from the property line
from the
now.
property line? Okay. Thank you.
Is the garage already 2-story?
It is not.
So you're gonna only make the second story of that L-shaped part you're adding?
No, it would be the entire
Okay,
garage breezeway, yes.
okay, so you're gonna lift it. Okay. I was
Yes.
a little confused on that.
So you really need, you can't add the second floor really without putting this on. Correct?
Correct, yes.
But isn't it more that you're just trying, because when I went to the back of your property, it's kind of like there's this little piece behind your garage. And then that open space where your sidewalk kind of goes into your back door. You're gonna,
Correct.
that L shape, you're gonna fill all that in with more livable space.
Correct.
And even if you didn't make that a second story, you still have the 4.5 foot issue because of just filling in that little bit, that L.
Yes, that's correct.
Right, that has nothing to do with the second story.
Right. But what I was getting at was he needs that there in order to add the second story.
He needs to add the L,
Right.
right.
Any other questions of the board?
Yeah, Commissioner, just a quick question for the applicant. Just curious, with the addition of the second story on the garage, will that make the roof line continuous, meaning even? Or will the garage be, it looks like it'll be above? I just wanted to confirm that it'll be higher than the roof line of the house.
There's gonna be some gable roofs added on to blend everything in properly.
Thank you.
Yeah,
So I actually, I really don't have any other question, Chairman, to the applicant. I have a question to the staff. Do you want me to wait until after the applicant?
No, go ahead and ask it, because that way we've run into problems in the past where we need to ask the applicant something.
Okay,
And I don't want to
So-
close the hearing without every opportunity.
so Jen, or Lori, the question I have is how we do the minimum and make sure that the minimum is in, when we say a variance from the street to the back line, right? We know it's that whole length, but since we're trying to look now at minimum, how do you make sure that the minimum ends up in the property, the right, whatever documents it is? How's that work?
So, hi, this is Lori. So what you can do is you could state the variance is only for this addition from this application, and it shall be no more than or no less than 4.5 feet from the property line. Now, this isn't a strict survey, so that 0.5 feet is probably a give or take. So, I mean, I would probably say maybe 4 feet. Just in case they go 4.4 feet. Does that make sense?
Well, are you
Yes.
looking at the thing that Rich put on the screen?
Yeah, I see that, yeah.
Okay, so you're saying if that 4.5 is wiggly, right? That's what
Yeah.
you're trying to tell me when
Yeah.
when we have the motion?
Mm-hmm.
All right, and we're specific that it's no more than what is needed for this addition. That'd be the words that we would use.
Yep. we
So
could
that it means,
Do that.
so that if this is where the commission goes, it means it doesn't go any further towards the street or towards the backyard. It's just
Right.
that corner.
And I would clarify that it will be a 2-story addition. Or that the garage will become 2-story. And that means that means that no other structure can go within that 10-foot setback unless they come back for a variance for it.
For whatever that future may hold.
Correct. Absolutely correct.
Okay. Any other questions to the applicant? All right. Is there anybody wishing to speak in favor or against? Anybody wishing to speak in favor or against? Anybody wishing to speak in favor or against? Sensing none, do I have a motion to close the hearing?
So moved.
I make the motion.
Made by Mary Ann. Who was the second?
I second.
I can't see. You have to.
Charlie.
Charlie. Thank you. All right. Discussion.
I think it's the least necessary is that 4.5, and looking at the other properties, none of them are squared on the properties down in that area. And in the whole neighborhood has built on or added additions here and there over time. So his request is very minor and it has no impact on the neighbors.
Anybody else?
I would
I
just
concur
add
100% with Mary Ann.
Okay, what were you saying, Andrew?
just say it's the lot creates the hardship. They're all parallelograms, those 5 or 6 lots over there, and that creates the hardship, having the lot at a different angle than the house.
Correct. Okay. We struggle with this, and we've learned now that we can actually do it without going the whole length of the property. And I think this is a good one where we can pinpoint the back corner and still be able to protect the property line. So I think that's a good thing.
Mr. Chairman, may I ask a question?
Who is that?
It's Rich, sorry, point of
Go ahead,
clarification.
Rick. Yep.
Just in terms of the approval, should it be mentioned that the line for the back of the house would be the line that continues, just for clarification of the approval?
What does that mean, Rich?
Yeah, what does that mean?
That back here. Just that the back of the house line continues, that it doesn't exceed. I don't know if you see the drawing here. So
Right.
It's got it drawn in. That's all I'm saying, just more of as clarification for your approval.
I need to understand what words you're asking so I can write them down.
That the new structure would not exceed the current structure, the main house.
Well, he wouldn't be
So I
able, he
I might
wouldn't be
say that
able to. He wouldn't be able to exceed that because then he'd get closer to the property line.
Right, okay.
But basically, you want to extend the rear line towards the property line, the rear line of the house towards the property line.
Yes,
won't.
those are the words, Lori. Thank you.
All right, do I have a motion to approve?
I make a motion to approve, and we're probably gonna need to work on this a little bit. Motion to approve ZBA 2021-0421 for Hollywood Drive to allow a reduction in side yard setback from 10 feet to 4.5 feet in order to allow a building addition and a second story to the garage to the existing home. Michael Fawn, owner applicant, map 73, lot 37, R33 zone, according to the materials submitted under ZBA 2020-04-21. Is that clear enough, Laura?
No,
Go ahead.
it needs to state that it's the back corner only. We're not reducing the side yard setback to 4.5. We're reducing the side yard setback on the back corner of the house only.
Okay, hang on a minute.
You could say just relevant to the structure.
To allow the extension of the rear line setback to the property line to 4.5 feet. Would that work better?
This is Lori again. So I think what you want to say is to allow a new structure to encroach up to 4.5 feet, which of the side yard, which will be a building addition with the second story. That is an extension of the rear house line.
The
That
rear,
makes it very specific to that structure and that structure only.
hang on, Lori, of the rear property line or
No. It's an extension of the rear house line.
house line?
So that's what Richard was referring to.
Right,
It's
and that's
like-
what I'm trying to,
So it's not bumping out further.
okay, so, go ahead.
Did we want to say the 4.5 or did we want to reduce it, give it the little bit of wiggle room? Because it wasn't,
The thing I'm concerned about is I think the applicant asked specifically for 4.5, so how do we change
oh,
it?
okay. I thought Lori had said and
Yeah.
give it,
I know she did, but
Yeah.
but that's what he asked for.
That's true.
okay.
Okay, so, does everybody kind of understand what we just said? It's to approve 4 Hollywood Drive to allow a new structure to encroach up to 4.5 feet, which will be an extension of the rear house line. Will that work?
Yes.
Okay.
4.5 feet into the 10-foot side yard.
To the 10-foot side yard.
For the expansion of the garage and for the expansion of the garage and a 2-story addition on the garage.
Ain't all that noise.
I wanted you to sit on this meeting with me. ZBA meeting.
Okay,
Okay.
is everybody okay with what we got?
Yes, Marianne, I'll second it.
I have a motion.
you, Andrew.
Andrew seconded it. And
That was
roll call.
Andy. Second.
Yep. Roll call, please.
Paul LaRosa,
Yeah.
Andrew Banowitz,
Patrick, can you mute yourself?
Excuse me, Marianne. Patrick, could you mute yourself, please?
Go ahead, Marianne.
Andrew Banowitz,
Yes.
Mary Ann Turner, yes. Charlie Master Birdie,
Yes.
Kelly Davis.
Yes.
Chairman, you have 500 in favor.
Thank you. Congratulations. You can talk with the people in the office in the next couple of days and they'll be able to help you move forward.
All right, thank you.
All right, Marianne, the next one is 11 Pearl Street.
I need you to wait 1 second.
Take your time.
Okay, I've got it.
Okay.
And I even wrote it on the correct paperwork. Yahoo. All right. Hollywood, 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 Hollywood. Hold on, I'm just getting rid of that so I don't goof up the next one. We're on to 11 Pearl.
Yes.
Second story, okay. Okay. ZBA 2021-04-14, 11 Pearl Street, variance application to allow a deck to encroach 2 feet from the rear property line where 10-foot rear yard setback is required under section 8.121. Winter Street Corp. Owner Patrick and Jeanette Talarita, applicants map 24, lot 65, TD5 zone.
Go ahead, Mr. Talarita, state your name and address for the record, please.
Patrick Talarita, 1400 Enfield Street.
Jeanette Talarita, 1400 Enfield Street.
All right, go ahead with your application.
I need a little guidance, probably. What, do you want me to just review the whole?
We're basically an overview of what you want to do,
Sure.
why you want to do it, and what the hardship that you find on the property causing the issue.
Okay, well, we're trying to do an adaptive reuse of a property known as the old Thompsonville Fire District building at 11 Pearl Street. The building was built in 1939. It was a firehouse until 5 years ago. It has been vacant thereafter. What we're trying to do with it is actually in accordance with the Thompsonville development plans and strategies, as well as the plan of conservation. We're trying to turn the property into a mixed-use building on the second floor of the building, which that all abuts Pearl Street. And the request is that it would be that you'd have a commercial application or on the first floor, which we are going to be going for approval from the zoning board of appeal, rather planning and zoning commission. On the second floor, we want to have a residence on the second floor of the property. It will be our primary residence. We want to make that into our retirement home on the second floor and operate a business on the first floor as we get ready for retirement. And what we'd like to do is, because the property is the building pretty much encompasses 90% of the property, and the rest of the property is pavement and driveway. We'd like to build a deck for outdoor living purposes on the second floor, on the back corner where we feel is the least obtrusive. Our desire is to keep the front of the building, restore it back to its original design. It's an Art Deco building. We want to preserve it for the Thompsonville district, make it an active use of building. But we do need some active outdoor space in order to put the grill outside and some tables and some chairs so that we can sit out there in the morning or the evening. There really isn't any other place to do that. I believe that's a hardship considering, current housing standards, to have some type of outdoor living space. So we are, when adding the deck, and I proposed a deck of 10 feet by 24 feet in the very northeast corner of the building, we would be coming within 2 to 3 feet of the town property line. And then it increases as we go down the building to where it's about a 5 or 6 foot distance from the property line. It will be at the second level. It will not be on the ground level. So it will be above to service only the second. And it's only for our private use. It's not for any other use. It's for our personal resident use. That what you're looking for from us?
Pretty much.
I did provide a narrative. I think you guys have a copy of answering the questions as to why we believe there's a hardship associated with it. And I think it really comes down to really what we believe is because we're trying to repurpose this building in accordance with the town of Enfield has strived to do in that area of town. But without the ability really to have any outdoor living space, it presents a problem for us. And really, there's not much else based on the fact that we want to utilize the front right side of the building or left side near the waterfall for the business application of attempting to do a little outdoor seating in that area. That really wouldn't lend itself to our use. And really, I think the hardship associated is just to be able to live upstairs and have that deck in order to just go outside and cook during the summer months and entertain. We really need something that's
Enjoy the nature of the pond.
enjoy the nature of the pond, the waterfall in that area there, and to keep ourselves above the not on the pavement below, on the street level.
Okay. Are there any questions from the board?
Hi, Pat and Jeanette. It's nice to see you. It's been a long
Hi.
time.
Hi, Mary Ann, how are you? We don't see you, we just
I
see your
know, we
name.
can't see you.
Oh, I can see you.
Oh,
See you. I do have a question that maybe you can just answer. Can you see the picture that's on the screen?
I do.
Okay. There's that little square that's down by that red car, but it looks like it's up high. It looks like there's a little blue inside. Yeah, right there. What is
Okay. That's the tower, the top of the
when
tower.
they used to put the hoses?
The hose tower.
No, it never was actually, everybody thinks it was, but it actually never was used for hoses. It was only used originally when the building was built in 29. It was used as a, oh, it's gone now. It was used as a, it's going. It was used as a, that's where the bell was that chimed where the fire was.
Yeah.
And then probably around the 1950s, they turned it over to horns. So that's where the horns were located.
So when
It's
you,
also-
so are you planning on taking that out and that area that's kind of what's left of parking lot? Are you gonna use that for your new business?
We're right. That's where we're proposing to do some of the. We're not gonna take the tower out. No,
Oh,
we're not
okay.
changing. We're not changing the structure of the building at all.
Okay,
Matter of fact, our desire is to preserve it. And I've been doing my due diligence on the building, and I've got masons to actually repoint that tower to fix all the Art Deco block windows as well. So we want to
Trying
bring
to
it.
restore it to make it look good down there.
We're trying to restore it to the 1939 design.
Yeah.
Absolutely.
well, I kind of chuckle considering that the lovely home you have on Enfield Street and all the lawn you have to mow, that now you're going to less than a weed whacker.
Right.
Well, we're going, Mary Ann, to not even a weed whacker. We're venturing out on an adventure.
Yeah, new season, as they say.
Yeah.
So they say.
Well, I think it's a wonderful project.
Well, thank you. We
Thank
do
you.
too. We're rather excited about it, but having this deck is an important component for us so that we can.
Want to see if you want, down in Windsor on Mechanic Avenue, Pat, there's a gentleman who owns that building. And he put a deck on exactly like what you're talking off of his third floor,
Okay.
where he turned his photo studio into a photo studio in his living space.
All right.
He did exactly the same thing.
It's in Windsor on Mechanic Avenue?
Yeah, when you go down into Windsor, where the CVS, that little area where Bill Seelig Jewelers
Yeah.
was,
Yeah,
there.
yeah.
All right, go down past CVS, go straight. And you go over the railroad tracks, and right in front of you is the building. Just go in the driveway and go to the back. You'll see it. He's got exactly what you're talking about, and I have to tell you, it's amazing.
Yeah. Did he
Okay.
do you know, did he do it with metal or did he do
Yes.
it with wood?
No, he used I want to say what do you call them, girders like.
Okay.
But I
Yeah,
know
we-
the fella who owns the building if you ever want to talk to him.
Yeah, thank you. We are looking for different ideas and we want to really kind of keep with the aesthetics of the property as well. Wow.
I guess your towers are going off.
Yeah, no, that's not us.
Hey, everybody could, if you're
Sorry,
not
that was my
speaking,
phone
please
ringing.
mute.
All
I
right.
have no other
Uh,
questions.
Are there any other questions of the board? Is there anybody in the audience wishing to speak in favor or against? Anybody wishing to speak in favor or against? Anybody wishing to speak in favor or against? Sensing none, do I have a motion to close the hearing?
So moved.
Second? Who made the second?
Kelly,
Okay. Roll call?
Mola Rosa,
Yes?
Andrew Abanowitz,
Yes.
Mary Ann Turner, yes. Charlie Masterbirdy,
Yes.
Kelly Davis.
yes,
Discussion?
I think it's a wonderful use of the building. I'm excited to see something so amazing happening, and I just think it's gonna be great, and I look forward to whatever it is you're doing downstairs. I can't wait to go there and hopefully hang out.
Yeah, we're gonna try to put a little tap room in there, seasonal tap room. Not make beer, but just have little, little food and try to attract people to Thompsonville in that area and try to be going home. I was born in Thompsonville, so I'm looking forward to it. We are. So thank you. Thank you all.
Thank you.
So we still need, any other comments from the board? Discussion. Okay. We still need to, as a board, come up with what, if it's going to be approved or denied as to why.
Well, I haven't made the motion yet.
Okay,
Would you like me to make the motion now?
sure, let's hear
Okay.
it.
I make a motion to approve ZBA 2021-0414 at 11 Pearl Street for a variance to allow a 10-foot by 24-foot second-story deck to be located up to 8 feet within the 10-foot rear yard setback. Patrick and Jeanette Talarita applicants, Winter Street, Corp owner, map 24, lot 65, TD5 zone. So now do you want to tell me,
Do
you're
I have
asking me,
Do I have a second?
Second.
All right.
okay.
Well, I think it's a great idea. I think there's a clear hardship of this being a unique property. With the fact that there aren't too many properties in our town or in any town that have a waterfall going through the backyard. Kind of limits the yard, doesn't it?
It does.
So a raised platform to be able to have some type of a yard experience, I think is a great idea. And I think preserving a building, repurposing a building that really would be very difficult to find a use for is got a great plan, I think. So, anybody else have anything to offer? If not, roll call, please. I know I'm going a little too fast for you, aren't I, Mary?
Sorry, no, I had some personal business. I had to take that call. Okay, so I got the part about a raised platform, so, and then my phone rang from my sister. Sorry, Pat. So
Looking for roll call.
answer. And we did the roll call, we did the second,
Now,
we're voting.
yes, we're voting.
Okay, Maurice LaReza,
Yes.
Andrew Abanowitz,
Yes.
Mary Ann Turner, yes. Charlie Masterbirdy,
Yes.
Kelly Davis,
yes.
Mr. Chairman, 500.
Okay, congratulations
Thank you.
to the two of you. Get in touch with the office in the next few days, and they'll help you move forward.
All right, here we go. Thank you.
Good luck.
Good luck.
Thanks.
We appreciate it. Have a great night, everybody. Bye-bye.
Bye-bye.
All right, the next one on our agenda is 69 Broadbrook Road. And we're gonna do them both separate. We've got an appeal from the zoning enforcement officer, which we're gonna hear first.
Okay,
You can read both legal notices at once, but we're gonna take them both
no,
separately.
I'd like us to do them separate.
Gotcha. We'll just read them separate then.
ZBA 2021-0208, 69 Broadbrook Road, appeal of the zoning enforcement officer's notice of violation of section 410 residential lot and bulk requirements. Jarmark Farm LLC, Jarmark Real Estate LLC, owner applicant, map 102, lot 49, R88 zone.
And I believe I saw the applicant's name here, correct?
Mr. Chairman, good evening. For the record, Carl Landolina representing
Mr.
the applicant.
Mr. Chairman, can I interrupt the applicant for a minute? I'm recusing myself from this meeting and the subsequent meeting. So you'll need to seat an alternate.
Okay, do you have an alternate?
Per my written message to you earlier.
Yep, do you have an alternate in mind?
You can seat whomever is available. Your discretion.
Mary Ann, who sat last time?
I believe that your next alternate is Rich Stroney.
Okay, Rich, are you available, prepared?
I am.
Okay, we're gonna seat Rich.
Very good. I'll be dropping off video, but I'll be listening in just to see when you guys are done so I can come back to the next part of the meeting.
Thank you, Andrew.
Mr. Chairman, if I may, I would have no objection. I think it would be a better use of everyone's time if you held the hearings consecutive or at the same time for these two matters. I believe the statute requires you to actually vote on the cease and desist first, but doesn't require that you have a separate hearing. So again, because a lot of the issues are probably going to be intermingled between the two, so I would respectfully ask that you open both hearings 1 and 2 on the cease and desist and the application for variance. But if no one has an objection.
Let's see. Just excuse me for the record, our attorney Derek Donnelly's, oh, there he is. They just let him in. Thanks.
Mr. Chairman, these are two separate things and they both need to be worked on. One could impede the other.
Yeah, I'm not sure I see a need to open them both together because if we find in your favor for the appeal, then there's no reason for the variance. So that they are two different matters. They have to be voted on separately, and just so that things don't get confusing, I'd like to keep them separate.
Oh, okay. I guess we'll do it that way.
I don't believe it'll take up any more time. I don't believe it'll be redundant.
Yeah. Well, all right, if that's the way you'd like to do it, I mean, frankly, the facts are the facts, and you all know what the facts are. I've been informed by, is Mr. Rosselli on? I didn't see Rick's name here, but.
He's on.
Okay. And I think his report was, factual. One of the things that I do need to bring to your attention is if you look at the chain of emails back and forth between Mr. Martin and Mr. Rosselli, and this is in the packet. You can see that on September, there was a back and forth between Mr. Martin and Mr. Rosselli about drawings and measuring and so on and so forth. And Mr. Martin did submit something to Mr. Rosselli. This was in September. And on September 29, before anything, the building department essentially had signed off already. They were waiting for zoning to sign off. And my client had been waiting for over 30 days to get something back. And on September 29th, Mr. Rosselli, in response to emails from Mr. Martin, talked about, again, the setback distance and so on and so forth. And there's an email that says, attaches the updated positioning of the building, taking into account the 50-foot setback off the right-of-way, the 10-foot distance off the barn that is staying, and a fair system, keeping a fair system away from the septic system. As it stands with this drawing, the building is 50 feet off the right of way, 13 feet off the barn, and just under 40 from the area of the septic system to the south of the driveway. Mr. Shelley's response was, okay, good, never saw that one. I assume he's talking about the drawing. And most importantly, it says, we will attach it to the permit based upon the proposed diagram. So, and approve it. So it was, now, I don't know if Mr. Richelli's signature ever got on the building permit application, but that was in September. And based upon what he had been supplied that thus far, he had in fact approved the location of the building based upon the drawing. So the building permit never got issued. 2 months later, the building goes up and try to make light of that. That's exactly what happened. And it's fair to say that the building permit never was issued to date because the building went up without it. And the building as constructed stands not as shown on that drawing, but in fact closer to the right of way. So that the building, once we realized that the building was closer to the right of way than is shown on the hand drawing, which it wasn't until we got the survey from Mr. Bussery, and we found out that in fact the building was 34.1 feet from the actual right of way. The crew that built the building, they are a traveling construction crew moving, up and down the East Coast. You get them for a week or so and they build the building and they move on. And they were engaged, months in advance in order to get them to build the style of building that they're experts in building this style of farm building. And they measured, as you can probably expect at this point, 50 feet off the pavement and not 50 feet off the right of way. So there was what created the problem. Now, in fact, there was a building on this property in that location that was 40 feet off the right of way. So, that was obviously a non-conforming building. And as we've discussed previously, you don't lose the non-conforming status since the law changed a few years ago with the demolition of that building. That setback still remains on the property to be used. So all along while this process was going on, Mr. Richelli was informing the applicant that he had a 50-foot setback requirement that he had to comply with. After the building was up, it was discovered by, I guess, town staff that in fact the regulations provide for a 100-foot setback for this type of building. So you've got a building that's 34 feet from the road, from the right of way, replacing a building that was 40 feet from the right of way, after being told the building had to be 50 feet from the right of way, when in fact, under the regulations, it appears the building should have been 100 feet from the right of way. So that's really all I have at this point on the application to overturn the cease and desist order.
So are you in fact saying that the cease and desist is a good order then?
What I'm saying is that.
Go ahead.
What I'm saying is that the building, there's no disputing the fact that the building is 34.1 feet from the right of way. And your regulations require a 100-foot setback, but certainly the town would be stopped from enforcing anything greater than 50 feet, given the remarks we have from Mr. Richelli in writing over a number of weeks. And the town, in my view, would be stopped under the new law as respects the statutes regarding non-conforming uses and structures from enforcing any regulation that required this building to be more than 40 feet from the road. Because the 40-foot setback, the front setback, was established as a valid non-conforming use for almost, well, probably 100 years. And the demolition of that building did not, in fact, abandon the non-conforming setback that was established at this site. So I would say the cease and desist order, to the extent that it claims that we are violating the regulations because our building is 60, I'm not good at math, let's see, 65.9 feet short of where it should be, I would say, no, it's not a good order.
Right.
That's
but
using 100.
That's using 100 feet.
Right.
But even if, but where I'm confused, Mr. Landolina, people are willing to say, okay, they talked 50, you know it was 50, dropped the building at 50, we wouldn't be sitting here today. I
Probably
understand.
not.
And even if you
Commissioner.
said, okay, we have the 40 feet from the 1917 building that got demolished,
Right.
you still went through that 40 feet.
Right. Yes. No question.
Ay, ay, ay.
So we are, I would say, if we are in violation, we're in violation by 5.9 feet.
We're not looking to see right now how far you're in violation.
Mm-hmm.
This hearing is to see if you're in violation,
Mm-hmm.
and you're clearly saying that you are.
I'm
So
saying,
speed it up and just take a vote on this and move forward with the other application. You're clearly telling us that you're in violation. So
you can take my words however you like them. I'm saying if we are, it's only by 5.9 feet.
okay. All right. Any questions of the board? Is there anybody in the audience wishing to speak in favor or against? Anybody wishing to speak in favor or against?
Yes, my name is Derek Donnelly. I'm another attorney who represents the owners of the property. And if I could just speak to the last point made by the chairman with respect to the order itself. If you read the order, the question of whether it's a valid order or a good order or not is on its face. It quotes the 50-foot setback as the reason for the violation, not 100 feet. It doesn't state what the regulations say. On its face, it incorrectly states the zoning regulations, and I think that in and of itself makes it an invalid order.
Okay. Any other questions of the board, from the board?
Mr. Chairman, this is Lori Witten.
Go ahead, Lori.
So it seems to me that the way I've read this is that, yes, the 50-foot setback has been consistent throughout, and I believe that Attorney Landolina is correct that should this have been built by those directions, we would be stopped, and basically we'd have to agree to allow that 50 feet. I don't think that's really in question. The point is that Rick went out there to investigate something because the North Central Health District had not gone out there, or they had gone out there and had an issue with the closeness of the well. And when he went out to investigate that, the structure was already up with a roof on it. So had we not had any construction, we could have solved the 50 feet or the 100 feet, or if the applicant wanted to come in for a variance to expand a non-conforming structure, because the structure is way bigger than any part of the house. So you'd have to get a variance to expand the non-conforming structure to the sides because it's 60 feet wide. We would have fixed all this. But the point is that the structure was constructed without a building permit. It still does not have a building permit. So it's really hard to fix things while we're reviewing things when it's already constructed. And that's why the cease and desist was issued. And
Okay.
I know Rick is on the meeting. If he wants to say something or not, that's his prerogative. If he feels he's got something else to contribute.
Okay, thank you. Is there anybody else wishing to speak in favor or against?
Mr. Chairman, one question if I could ask of staff.
Go ahead.
Lori, what
is that? Could people please mute?
what is not complete yet on the permit? What is holding them up prior to the cease and desist?
North Central had not signed off and planning had not signed off.
Okay. Thank you.
So therefore the permit was not issued.
But it's my understanding that this is the only thing that's holding up the issuance of the permit at this time, right?
Well, I don't find anything in any of the documents I read and 99 emails where the health department agreed that they're in the right place, the building's in the right place to the well. If someone can find me that, I'd love to read it because I couldn't find it. Do we have anything from the health department?
Not to the best of my knowledge.
There's nothing in the documents that I read.
Yeah, this is Derek Donnelly again. The health department did have an issue with the location of the old well. They did verbally sign off on that with the client and told Mr. Jarmock that they would send an email to Mr. Rochelle about it. That occurred, I believe, sometime in October, and that email apparently never went in a timely manner to the zoning department. That's as I understand it.
Did you ever get a copy of that from the health district, from Mike or from Ms. Sulik? Because they don't do things verbally. I was on the health board for 10 years.
Well, verbally, they said they would send an email to Mr. Rochelle. We learned later that they did not. So
did you follow up with
that? Respectfully, Madam Secretary, the health department is not the issue before you today, nor is the health department sign off before you today, nor ultimately is whether the building department issued the permit or not. That was brought up by Ms. Whitten. Those are not the issues before you, respectfully.
Respectfully, Mr. Attorney Donnelly, I was trying to be of help to you. I'll take that under advisement.
Go ahead, Mr. Rochelle.
Yeah, so just to address some of those points, I'm sorry I got cut off, my internet dropped, but we never got any confirmation from the health department regarding that well. They're one of the reviewers on all the permits that come in. That was the reason why I went out in November because we didn't know that the actual building had been constructed at that point. And when it was viewed, when I went out there, that's when we saw that it was actually under construction without a building permit being approved for it. And obviously the appearance of its vicinity so close to the road, it actually was apparent that they did not follow what they were approved for. And that was the last one that Mr. Landolina, or Attorney Landolina, was talking about in September 29th. We do a review and we base our approvals based on what's submitted by the applicant and hope that the applicant follows those site plans or those plot plans that they submit for measurements to come into compliance.
Okay.
This is Owen Jarmock on behalf of the applicant. To the Secretary's advice, we were very thankful for your advice in trying to guide us down this path. We do have an email on November 19th from the health department approving this to the extent it was sent to the building department because it's not part of any zoning issues before you tonight.
Does anybody have a copy? Because it's not in my packet.
Nope.
All right. Does anybody else have any comments or questions to the applicant?
Lori Witten here. So, it seems to me that had they built the structure with the permit at 50 feet, we'd be all good. But they didn't even meet the 50 feet. And they never asked for a variance to expand a non-conforming structure. So that's part of the story.
Okay. And as usual, the applicant will have final say. So do you have anything else to add to that, Mr. Lanalina or Mr. Jarmock?
No, I don't have anything, Mr. Chairman, to add to that.
Okay,
I would, no, that's fine.
okay. Do I have a motion to close the public hearing?
So moved.
Made by Mary Ann. Do I have a second?
Second.
Charlie Masterbirdy.
Okay,
Mola Rosa,
yes?
Mary Ann Turner, yes. Charlie Masterbirdy,
Yes.
Kelly Davis,
Yes.
Rich Stroney,
Yes.
All right, do I have a motion to approve?
I make a motion to uphold the decision of the zoning enforcement officer in the notice of violation dated January 7th, 2021, stating that the recently constructed structure is within the front yard setbacks of the R88 zone as required in table 4.10 of the Enfield zoning regulations.
Do I have a second?
Second.
Discussion.
I believe that the zoning officer did his job properly, and the applicant put themselves in a position where they could have gotten 50 feet when farms know full well they're supposed to be 100 feet.
Anybody else? Okay, we do know that non-conforming uses will say non-conforming uses, but when you tear the building down, it works a little bit different. This would have been an expansion of a non-conforming use. And they would have had, as Mary Ann and as Lori pointed out, because Rick cited the wrong distance, they could have fallen into that gap. But I don't believe that the town is stopped, because if they had taken that mistake and run with it, they would have gotten what they wanted, 50 feet. But because they didn't even comply to that, they're kind of stuck. So I believe that the zoning enforcement officer did the right thing. And they're gonna, now they have to seek a variance, otherwise they have to put the building 100 feet from the road. And that's, I don't believe that that's holding the town in any harm, because they violated the regulation and they built it without a permit. They still don't have a permit for it. So I believe that the cease and desist is valid. So with that, roll call, please.
Mola Rosa,
Yes.
Mary Ann Turner, yes. Charlie Masterbirdy,
Yes.
Kelly Davis,
Yes.
Rich Stroney.
Yes.
Mr. Chairman, the commission upholds the zoning enforcement's notice of violation.
Okay. Can we read the next legal notice, please?
Give me 1 second.
Not a problem.
ZBA 2021-03-23, 69 Broadbrook Road, variance application to allow for a barn to be located 34.1 feet from the front setback where 100 feet is required under section 4.60.2A. Jarmark Farms LLC and Jarmark Real Estate LLC owner Stephen Jarmark, applicant, map 102, lot 49, R88 zone.
All right. Before we get going on this application, I want to remind everybody that this is an application now for a variance, and we're now looking for a hardship on the property. So will the applicant go ahead with the explanation of their application for a variance?
Yes, Mr. Chairman, good evening. For the record, Carl Landolina representing the applicant, Jarmark Farms and Jarmark Real Estate LLC. So just so we have a separate and complete record, I'm going to repeat some of the things I said earlier about the history of the building application and the zoning sign off for this barn. As we all know, the regulations do say that this building in this particular zone should have a front yard of 100 feet. There are numerous examples in the record of the prior hearing and the documents that were submitted both by my client and staff to establish that at the time discussions were taking place, Mr. Richelli had informed the applicant that the setback requirement was 50 feet. Obviously, there were discussions about where that was measured from and so on. There was a prior building in this location that, to the best of everyone's information, was 40 feet from the right of way. That building was demolished. The setback, the non-conforming status of that setback was not abandoned, given that the new building replaced the old building fairly soon after the old building was torn down. I would respectfully ask you to take a look at section 3.40.2, non-conforming structures of your regulation. It's on page 30. And I think this is where I have a little bit of a disagreement with staff. You'll have to bear with me because this is a fairly technical and sort of subtle argument. I know you're all capable of understanding this, but I want to
Mr.
make sure that
Landolina, I
yes.
missed, it's 3.40 point what?
Two.
Thank you. I just want to make sure I'm in the same place with you.
Yes, thank you, Commissioner Turner. So it says any building or structure legally in existence at the time of the adoption or amendment of these regulations, which does not comply with the minimum floor area, height, bulk, lot coverage, or other dimensional requirements of these regulations shall be considered a non-conforming structure. So let's stop there. So we're talking about the structure that was built in 1917 that was 40 feet off of the right-of-way on Broadbrook Road. So that clearly was a non-conforming structure because it did not meet the dimensional requirements of the regulations when the regulations came into existence. And your regulations probably go back into the 30s. I think we don't have to go through the history, but at some point, this became an R88 zone and the requirement was 50 feet. So this structure was in non-conformance with the 50-foot setback whenever that was created. And when it was created, it's not important for our purposes. So we've got a non-conforming structure under 3.40.2. The next sentence says such structures may continue to be used subject to the following conditions. A non-conforming structure may be expanded, altered, or extended, provided such expansion, alteration, extension does not violate or further violate any of the height, bulk, setback, or landscaping requirements for which the zone is situated. Okay. So if you look at that, there are two ways to read this, and I would submit to you that one is more reasonable than the other. If I have a building that is, the front of my building is 10 feet closer to the right of way than it should be, but the rear of my building is beyond the 50-foot setback. If I added something to the back of that building, I would not be in violation of the zoning regulations. The only time I might be in violation is if I extended the building at its front part so that, let's say the building was 40 feet wide, and I now made it 50 feet wide within that setback that I've already encroached on 10 feet. If in the first circumstance, this sentence would make absolutely no sense to think that that had anything to do with enlarging a building in a way that didn't violate the zoning regulations. It wouldn't need to be in there.
Can I interrupt you? Can I interrupt you for one moment?
Yeah.
You're talking about a structure that exists, and we're talking about a new structure.
Understood. I
So,
understand, Mr. Chairman.
so you're bringing us down a rabbit hole of a section of the regulations that talks about expanding an existing structure.
Correct.
You're not expanding an existing structure. You
I
built a
understand,
new structure.
but in the last hearing, I heard from staff that even had we located this building where we did, in the 40-foot area, we would have needed a variance. And respectfully, I disagree with that position. And I think that this is an important point. So that does not mean that we could only have built a structure 40 feet. And what I'm getting to, Mr. Chairman, is that even though technically we are asking for a 65.9 foot variance, as a practical matter, the variance we're seeking is only 5.9 feet because we could have built the barn 40 feet off the right of way and still been in compliance with your regulations as it relates to non-conforming uses. And we know that we could have done it at 50 feet probably because of the estoppel argument. So I know, you know, in one sense, we're looking at a fairly large request here from 100 to 34.1 feet, but in reality, as a practical matter, I'm trying to get you to understand that the request is really the difference between the 40 feet that was already granted to this property and the 34.1 feet where the building now exists. So that was the point I was trying to make.
What I'm trying to point out is that 40 feet doesn't matter because that mattered if the building that you had there was added onto. It wasn't added onto, it was demolished.
Understood. But
once that building comes into conformity, then it's done. If you had added onto it and then taken it down, then you added onto it. When you started with nothing, that regulation you're reading to us doesn't take any effect in it anymore.
Well, respectfully, I would
Mr.
disagree, and I'm
Chairman.
just trying to make this point for the record. But I'll move on, Mr. Chairman. So,
Thank you.
So one of the things that the regulations require is that there's a hardship shown. And I would submit to you, farming is unlike any other activity in the town of Enfield and any other town. If you have any other, it is in fact a commercial activity. I'm not going to try to tell you it's not. Farming is a commercial activity. And this is the only type of commercial activity that there really are no boundaries as to where it can take place. And what I mean by that is I have 10 acres. I can grow 10 acres of tobacco or green beans or whatever it is I'm growing if I am a farm. I'm not limited like other commercial activities, which normally require a building, let's say a manufacturing building. All right. So I can't manufacture my widgets outside of the confines of my building, which have to meet certain requirements as to setbacks and so on and so forth, and coverage and all the rest of it. Farming is a unique activity. So, and farming as a means of making a living, obviously is a very difficult way to make a living these days. Always has been, and it's been, at least in New England, a very protected way of earning a living because farms are being lost to subdivisions and other developments. So you have to protect as much of the land as possible. And one way to do that is to take the buildings, which are a necessary accessory part and component of farming, and not take up as any more arable land than possible. So if you look at, and this is clearly shown in this application, Mr. Chairman, if you look at the photographs that were submitted as part of the variance application, you can see that this new barn is really no different in terms of its location as to almost all the other buildings located on this property. In fact, this barn is actually further away from the road than another non-conforming barn that probably predates zoning and some other structures on this property. There are really no abutters or near neighbors to these buildings. The Jarmark farm goes along three sides and you've got a road. So with respect to the issue of harmony, this building is in harmony with the agricultural buildings in this area. And I would submit if you drove around town, probably with most of the agricultural buildings that either haven't been torn down or haven't been lost to fire or whatever, the rages of time. So I think the uniqueness of this activity, I think, demands that buildings be located as outside of arable land as much as possible. So I think that's the thing that creates the hardship here. And again, my point with all the other information was that yes, it's a 65.9 feet request, but as you know, my view of it is it's a much smaller request given the non-conforming status of other buildings that had once been located there, and unfortunately, had the things gone differently, we'd be having a different discussion. But this is the discussion we're having. So, based upon all of that, I believe this to be a proposal which is in harmony with the neighborhood and which shows a unique hardship on for this particular property. They may not exist for other properties similarly situated. I'll be glad to answer any questions that you may have, Mr. Chairman, or members of the board.
Okay, Rick, we'll get to you in just a second if you could hold on. Any questions of the board?
I guess the question is, you built the barn without a permit.
Absolutely, yes.
It just makes this so much more difficult. And I noticed that there was other barns that had gone perpendicular to the road, but this particular barn is facing out towards the road, and I didn't go on the property because I noticed from all the dialogue that was kind of a bone of contention with the owners, so I could only see what I could see from the street, and I didn't have anyone I could ask to go walk in the back.
Yeah.
But tell me what's behind the barn, because I saw another barn. And
so I'm going to have to ask my client to answer that question, but you can see that the shortest side of the barn is facing the road, and the long side, so it
is going
backwards, right? 200 feet.
On behalf of the applicant, there is another barn directly behind this one. In between barns, there is prime tillable farmland that we have farmed for probably since my grandfather came to Enfield in 1909 and started this business. 1907. There is a lot of farmland back there in between the barns and on the side of the barns, to the extent of the question. Most likely, I would imagine that farmland will be hay for a newfound horse that we have since adopted and rescued. But it is deemed as prime farmland from the United States Department of Agriculture.
Are we saying between the Rich, stop right there. Are we saying between that darker colored barn and the new red barn, you're gonna put hay? How you gonna open the doors of the barn?
Yeah, absolutely. We're gonna put hay there. We're in a situation now where farmland is becoming more and more scarce in the town of Enfield as it gets developed. So we are, if you will, looking for every last sliver of tillable acreage. And with respect to hay, it's very easy to mow. It's almost like grass. Easy to maintain. So we are, in search of farmland everywhere we can find it.
But I see the new solar farm butts pretty close to this new barn.
No, there's a lot of space next to the barn, probably 50 feet or so. Plenty of space to afford us the opportunity to grow some nice hay.
Excuse me.
Any other questions from the board? Sensing none. Oh, you got something, Marianne?
I guess what the question is, what's the hardship? What's the property doing? Because I know we didn't state it, but Mr. Chairman, maybe you need to explain what a hardship is.
Well, a hardship is something that affects this parcel of property uniquely from any other parcel of property, i.e. topography, water, things of that nature, odd shape.
A hardship also has to do with if it's flat or has a hill or a escarpment, but it also can't be self-imposed.
Right, can't be self-imposed or financial.
To the extent of your question, the hardship is scarce prime tillable agricultural land, deemed by the United States Department of Agriculture. By moving this building back to the 100 or 50 or 40, I'm confused about the setback. That's by the legal team. But by moving it back, we'd be sacrificing potentially 65 feet of farmland.
Well, wouldn't you?
Why'd you build the barn so big then?
The size of the barn is relative to our operation.
But if you need more slivers to grow hay, maybe the barn could have been a little smaller.
Right, it's not privy under regulations about what size barn we build, but.
Well, I'm understanding your hardship.
The hardship is the type of soil that exists on the property that is hard to find. Connecticut River Valley has some of the best soil, if you will, in potentially the world. Sicily, Italy is a close second. But the soil condition here is unlike another.
And it's under your new barn.
That's actually incorrect. All the organics and topsoil were stripped, and they were spread and redistributed back out to some of our other farm fields. If you drive by Abbey Road, for instance, this evening or tomorrow, you'll see big piles everywhere. That's actually topsoil from underneath the barns. You can't build on organic topsoil. It's not suitable for construction. Building department would not appreciate that.
So let me ask you this: couldn't you move that? Couldn't you have built that barn 100 feet back and made in front of it growing land?
Farmed what land? I'm confused.
You could have farmed closer to the road. You could have moved the building back and you could have farmed closer to the road.
No, not with the house there, or even if the house was removed, road salt and debris from the road actually contaminates land. And emissions from vehicles, if you will. If we're trying to generate animal feed next to the side of the road, there could be glass, debris, stuff that you wouldn't want to eat, and certainly stuff we wouldn't want to potentially feed animals.
Okay. As I drive through the other farm areas in town, you guys have crops growing within 10 feet, 5 feet of the road.
I can't speak to other farm areas where we are one of the farms in town. But to the extent of your question, I'm not sure which fields you're referring to, so I couldn't speak to them.
Okay. All right. Mr. Rochelle, you had a question?
No, I actually had a comment regarding the supposed hardship. Again, they can't be self-imposed, and there is enough area, 100 feet back, to place the barn, the same barn, parallel to the road. Right now, there's 8 buildings on that property. Putting another one on there is self-imposed. They didn't have to go there. As a matter of fact, they have an application in now for a barn across the street on property they own. So trying to jam in another barn, a structure on that property, that's self-imposing. That's doing it themselves. They made the decision to do that. Although they do have enough space to put it parallel to the road, they chose not to. The other issue is, I'm not sure if it was brought up before or not. 65 and 69 were merged. They were merged and approved for that merge of the 2 properties back in August, prior to the application for the barn going in there in the first place. So granted that the house was on a very small lot and non-conforming, both properties were merged into a much larger property, that being now 69 Broadbrook Road. Also, the limitation on the amount of property there, it's also self-imposed by the amount of property leased out for the solar farm. That's not something that we did, that's something that they did, creating a smaller space to put a barn. And again, as I said, that's self-imposed. It's not a hardship.
Okay.
Mr. Chairman, if I may, again, for the record, I respectfully disagree with Mr. Rochelli's
Hold on.
analysis.
Hold on. You'll have you guys will always get the final say.
Okay.
Okay. Right now, we have other people in the audience that want to speak in favor or against. We give everybody the opportunity. So, is that it, Mr. Rochelle?
Yeah, that's it for me.
I don't know if I could raise my hand.
Yes, Lori, go ahead.
Yeah, I don't have the ability to raise my hand, sorry.
No,
Or maybe you do, I don't know.
No,
Yeah.
you don't, because you're the one hosting it.
Yeah, but, so, Attorney Landolina, was referencing, or, 3.40.2A, and I agree with them in the sense that it allows expansion, but it only allows expansion at the level that the nonconformity exists. But it also references that you can't go beyond what already exists for, like, for front yard setback. If it's at 40 feet, you're not supposed to go more forward than 40 feet. And if you go to the sides, then that would be an expansion of a non-conforming structure. I think that that is referencing the fact that you can expand provided that you're not enhancing the non-conformity. Now, with that said, I just thought I would just try to make this simple. Let's assume that we were going to go for the 50 feet and then the applicant said, you know what, we would really like to seek a variance for an expansion of the non-conforming structure based on the structure that was taken down. They come to you and say, we really would like to go to 40 feet. And you'd probably be fine. You know, it's like, okay, it's a farm. You're right. And again, farming is unlike any other commercial use. And there's structures everywhere, and there's farming everywhere, and there's plants and animals everywhere. And, you know, there's very little setbacks required. So they come to you, they seek a variance to expand a non-conforming structure with a new structure, and you say yes. And they build it, and it's now 5.9 feet closer to the street. What's the hardship? And they come back to you and say, oops, we built it in the wrong place. Now, all of this could have been prevented had they not built it without a building permit.
and the thing is, Mr. Chairman, where I get confused is why wasn't it pinned? I mean, when I built my house, they had to go out there and literally stake
Survey.
the area so that when they came to put the foundation in, they knew exactly where it was going.
Marianne, let's hold on with thoughts like that until our discussion.
Thank you.
Do we have any other people in the audience wishing to speak in favor or against?
Mr. Chairman, I just have a question, and maybe Attorney Landolina can address this, because he quoted 3.40.2A, but B clearly talks about demolishing structures. What happened to the structure that was there that this barn is now replacing?
It was demolished.
Right, so I struggle with understanding how A applies versus B in that section for non-conforming structures, and maybe that's something that we need to discuss as well. I guess the question, just for clarification, does that then remove the non-conformity of the property?
Yes.
Okay,
So,
thank you.
so Mr.
Actually-
Chairman, I think we had this conversation before. We discussed how the non-conforming status has changed through the statutes and case law. So that structure would still have non-conforming status, even if it was demolished. You can, even if there was actual intent to take the building down, they would still have the status of non-conformity as to
The
front yard
structure,
setback.
the way I understand the way it's read, if I tear down a 4x4 structure that is legal non-conforming, I can then put up a 4x4 structure. They took down the house and they put up a much larger structure. They didn't replace what was there. If they'd replaced what they took down, it would be we'd have a different question. But they didn't replace it. They put something different there. So the 40-foot that was there for that house has been abandoned. They decided to go with a different structure, which brings in a different set of regulations. Because remember, a house, we can give leeway towards the front setback. But in the regulations, it clearly states a farm building, not a house, but a farm building has to be 100 feet from the road. So when they took down a house and put in a farm building, it's different. It doesn't follow the same regulation.
Like that, there is still a case law, and we understand that our current non-conforming regulations are a bit out of date, which is why we are redoing our zoning regs. Well, one of many reasons. But I mean, you've got a point with it's now a farm building and not a house, so
Correct.
the
It's
setbacks
two
theoretically are
different
different. But even if they came in for 50 feet, as they were initially told, they still didn't build it to the non-conforming setback.
Correct. We still don't have a building permit. So essentially, they haven't even asked to build a building yet, but we're here looking at a building. So we're gonna get to that in discussion. Is there anybody else in the audience wishing to speak in favor or against for the last time? Would the applicant like to add anything?
Yes, Mr. Chairman, I would.
Go ahead, the floor is yours.
Thank you, Mr. Chairman. In response to some of the issues raised, let's talk about the notion as brought up by Mr. Rochelle of a self-imposed hardship. No one needs a second garage on their property. If they want to have one and they come to you asking for a variance, under his analysis, that would be a self-imposed hardship. Under his analysis, if I was a manufacturer and I outgrew my building and I wanted to build an additional building or an addition to my building, and I needed a variance in order to fit it where I wanted to fit it, under Mr. Rochelli's analysis, that would be a self-imposed hardship. Because who needs a second building? Who needs a deck off of the back of their house? Who needs to put an addition on their house? So that's, you know, we all know that that notion just, to me, is wrong thinking. My client isn't going around building barns for the pleasure of it. He's going around building barns because he needs the space. Just like anyone who wants to put an addition on their house doesn't do it just to frame the building and let it sit there. They want and need the space. In this particular set of circumstances, his business, thankfully, is growing. And he needs the storage space and the barn space to accommodate his growing business. A growing business that needs more space can't be looked at as a self-imposed hardship. Secondly, and I think Lori already answered this, one of the commissioners asked about Section B. Section B, with due respect, you should ignore because Section B is unenforceable. 3.40.2B is unenforceable as it sits in your regulations. And I'll give you an example, just what you talked about tonight. And I've sat in a couple of your meetings lately, and I wouldn't say you struggle with this, but you want to make sure that when you grant variances, you grant them only for the thing that's being asked for. For example, the first gentleman who asked to put an addition on, and he was going within 4.5 feet of the side into the 10-foot setback or something like that. And you said, look, we're going to grant this, but only with respect to the area where the addition is going. And the reason you do that now is because you know full well, if I came in and asked for a 10-foot variance on a side yard, which should be 20 feet, and I'm asking for 10, if you don't limit it, it extends the entire way across that property boundary. All right, so you've given me carte blanche to build anything that I want within that setback area because you've now reduced my side yard and across the entire side yard from 20-foot setback to 10. And that's the way most commissions used to do it in the old days. And frankly, some of them are still doing it now. At least you guys have caught on to the fact that we don't want to do it that way anymore. So this notion that this 40-foot building, all right, since it was 4 by 4 or whatever it was, only encroached in that area, okay, I don't believe that's correct, and I respectfully disagree. That the existence of that building, and we know the fact that it's been destroyed and taken down, is of no matter, of no moment now. Section B doesn't exist. The statute says it doesn't exist. That 40-foot setback extended across the entire width of the original property, all right, which includes, I think, almost everything that this barn is built on. So, Mr. Chairman, I would respectfully disagree with your interpretation of that fact. Now, having said all that, the reason why we've gone through this entire machination, besides the fact that, look, we've got a building there, we've got the cart before the horse, and I understand that, okay, the frustration with that level. But this is where we are, but you have to look at it. If we weren't there, I would be making an argument that this is really a de minimis request because we have this 40-foot setback, which has not disappeared. And we want to build this barn a little bit closer, 5.9 feet to the road than the 40-foot setback that we already have a right to do. So that distance to me, that 5.9 feet is de minimis. And the court has said, all right, when someone's asking for a de minimis setback variance, that the courts, that the zoning boards of appeals can find that that's an appropriate request and can grant those kinds of variance requests. So that's what I'm asking you to do. I know look, to use an old farming, right, analogy, the horses are the barn, all right? We know that. The building's there. But forget about whether we've got a building permit or not. To build the building where we want it, where we would have wanted it is right where we put it, pretty much. And had the building not been built and we were coming before you, we'd be asking for what we consider to be a de minimis request in the setback for this particular property on this particular building. And we think that we would ask your indulgence and we would ask that you approve this variance request. Thank you, Mr. Chairman.
Mo, are you in there?
We lose him?
Well, I heard every word you said, Carl.
Thank you. You listened to the end. That was good. Thank you.
It looks like Maurice is still here, but
Looks like
not
he's muted.
muting.
Oh.
Yeah.
Ay, ay, ay. Let's see if I can get him to answer the phone.
Hello.
You're muted. We can't hear you.
I can't hear any of you. I lost all my sound.
Well, we heard everything.
I'm trying to figure out what.
Log out and come back in.
All right, I'll be right there.
Lori, he's got to come out and come back in.
Yeah, we all heard.
That's why I put him on speaker.
It happened to me last week with a judge. I lost contact and I had to call somebody and they put their phone up to the computer so the judge could talk to me.
Oh, God.
That's good. I don't know what happened. All of a sudden, everything went silent.
Yeah.
So, okay. Any other questions to the applicant from the commission?
I have one.
Go ahead.
My quandary for me is I am totally in agreement that if you'd come for a variance and you had made the case for, and it's a beautiful barn. My grandparents were farmers. I get it. I don't know how to get past the fact, again, that we don't have a building permit, and that may seem very minor in the scheme of things because they still have to pay for their barn and they still have to get the building permit. It's sometimes frustrating, Mr. Landolina, to try to work in this situation. I mean, I totally understand the farming issue. I totally get that they have a farming business. I totally understand the need for the barns. I get it. And I really did go out and look. I take the job seriously. I know you do. I need help getting over the hurdle of the fact that the barn was built. And truthfully, we need to be careful how we communicate with each other in writing. Some of the emails probably could have been a little easier on the tone. We have to be careful. Because in the end, the point is to let this business thrive. And this really is, in my opinion, a very minor requirement. And I don't know how, and I have to look to our staff. How do we get over the hurdle that there is no building permit? I don't know.
I understand your quandary, Mrs. Turner, and believe me, I get it. What I can say is that, it's hard to not look over there, right? To the building side of it, the building department side of it, because the building's up. I get it. It's not like I'm trying to hide that from you or anybody else, and I understand the position that you're in. Believe me, I get it. That is, the legal argument is, hey, that's a separate, that we'll take care of that when we need to. But the real argument is, what we're asking you to do is essentially look past that at this point, and some of the other things that, and look at it from a legal perspective. It's a de minimis request, and is it something that if that other issue wasn't there weighing you down, was it something that you would have given due consideration to? And I know you would have.
Well, keep in mind, for me to my commissioners, is that we make a decision today in one direction and say, okay, we see it, it was a misunderstanding, things happened, got it, right? Tomorrow morning, ABC farmer shows up and they do worse. And they come in front of us, and the first thing they're going to say to us, well, you know, over there on Broadbrook Road, I am so stuck.
Okay.
Just one quick question. Sorry to interrupt. Do we still have Mo on the line?
You do.
Okay. Just want to make sure you're still there, Mo.
Any other questions from the board to the applicant? Sensing none, do I have a motion to close the hearing?
Wait,
Hold on.
Mr. Chairman, Lori Witten again.
Go ahead, Lori.
So, I agree with you, Marianne. This is a really, really sticky position that you're in.
Is this to the applicant, or is this what we should?
This is, I'm talking to the commission at this point.
Okay, do we want to do this in open hearing or in discussion?
Yeah, no, we should do this during the hearing.
Right, right. Keep it so that the attorney can communicate.
So the attorneys and the applicant have a chance to, comment.
Okay.
So, I guess the one thing you could do is, as Attorney Landolina suggested, is just, if they came in for the 40 feet based on the non-conforming 40-foot variance based on the non-conforming structure, and then said, we'd really like it like 10 feet closer. And we have a lot of other buildings that are closer to the road. And it's really, you're not going to see the difference between 40 feet and 30 feet. And, I don't like the fact that, let's say, what are the alternatives here?
They're bad.
Do they knock it down? Do they knock down 10 feet? Do they, what are the alternatives? And is this de minimis? Is it going to make that big of a difference? I'm trying to be nice here to give you guys some sort of an out.
What I'm concerned about, there are other farmers, and there's farmers amongst us, and they should not feel that their hands are tied at times because they're farmers and they need that leeway on their property.
Yeah.
And we are the Connecticut Valley, as it was mentioned, and it's kind of our heritage. And I'm frustrated a little because I really do think that there should be a little bit of an act of contrition here. And we should be very careful with written commentary because it doesn't help with an outcome. And
I should be very specific.
Right, and I get frustration. I have been known to write my snarky email myself. And they have bit me in the hiney a couple of times. So I'm just saying, I think that farmers have enough problems. And I think we need to find a way to make this work.
Yeah. I would say that most towns do not require a 100-foot setback for a barn unless it's housing animals. So that's one thing that we should change anyway. I think that we're way over restrictive for the location of a barn.
Well, we never asked what's going in the barn, but I assume it's hay or something.
I believe it's there. There are no animals.
Right. Anyway.
On behalf of the applicant, we do take your comments under consideration with regards to some of the language and words used in the emails. As a business, it was sometimes frustrating. They were potentially rash and wrote in rather quickly to try to keep the timeline moving forward. So we do apologize for that. Also, for your consideration, we have built an additional 7 barns in town and increased the grand list in town with 7 new barns after this one. And after kind of determining the process for building permits, all that, every barn has been built with a permit. We have an excellent relationship with all the town departments, even with the hiccup in the road with zoning. And so to that extent, we really do appreciate your comments.
One question for the applicant, Mary Ann, you brought it up. What is going in that barn? Might as well ask that while we can.
The primary purpose of the barn is non-motorized farm equipment. We will store some farm products in there. Pumpkins has evolved into a very large portion of our business. We grow a lot of pumpkins outside of the town of Enfield, and we bring them into Enfield to ship out on our trucks. We carry pumpkins actually, everywhere on this side of Mississippi on some of our own trucks. But so it's really, the building in a sense has to be like a Swiss Army knife. I always carry one as a farmer. It has to be able to accomplish multiple different tasks at hand. So really, we built it to kind of, be multi-functional. In the winter, it'll store farm equipment. In the fall, I wouldn't be surprised to see some pumpkins in there. In the spring, you could see hay. It varies.
All right, any other questions to the applicant? Do I have a motion to close the public hearing?
So moved.
Do I have a second?
Second.
Close the public hearing. Mo Rosa,
Yes.
Mary Ann Turner, yes. Charles Masterbirdy,
Yes.
Kelly Davis,
Yes.
Rich Stroni.
Yes.
Discussion.
Mr. Chairman, I think we need to have some latitude with the applicant. I'm not happy that there was no building permit. I'm unhappy about the dialogue that went back and forth with our zoning enforcement officer. He is a professional, and I think that he tried desperately to do his job, and that we as public need to be careful how we treat them. But on the second side of the farmer, maybe there was no malicious intent, and maybe this has happened in the past, but I hope that it never happens again. Because this is the second time that I have sat as a zoning commissioner, and I've been here a long time. And people need to try to follow the rules to the best they can. Accidents happen. Malicious intent needs to stop. But on today, it is a beautiful barn. It is exactly where it should be. It's a farm, and it's not making a bit of difference if they had come to us for the variance, because now that we've learned the new rule of minimum and maximum, it's just my opinion. I'm not steering you one way or the other, but I do think that we need to be a little more on this particular moment.
So, this is Kelly. So, I struggle with the building permit also, but through this hearing, I just tried to view it as the building was not there in how I would go about with the variance. I do have a question, because there was no building permit, and if we do grant this variance, is there something that gets done on that end? We
don't care about the building. We're granting a variance for the land.
I understand that part. I was
So
just,
that's up to the town if they want to make him pull a building permit or not at this point. We have no say in it. All we're doing is saying, yes, you can build that close to the road there, or no, you can't build that close to the property line, rather. That's all we're saying.
okay.
So
We'll take care of the permits, no worries.
pretend like the building doesn't exist. Our job is to say, yes, you can build that close to the property line, or no, you can't. Any other comments?
Mr. Chairman, I struggle with this just from what I've been taught related to the ZBA and hardship, and also, does this create a precedent for other farmers in town who may also inadvertently build too close to the lines, right? So Certainly, the law creates precedents. Are we then creating a precedence for the other farmers in town where they may not be as fortunate with an outcome, depending how this goes? Right, so that's more my concern here, because it clearly says in the application that there's a hardship, or a hardship exists. Self-inflicted doesn't count for consideration. Certainly it wasn't handled well, and certainly lack of permit creates an issue here from a decision side of things. Again, I have concerns with the precedent that this may set, where other farmers may not be in a position to benefit from it, or may use this as a means for their own benefit. And I don't mean that in a negative or a derogatory way. Just simply, it's one of those situations that creates a decision set for us.
And Commissioner Stroni, it's not just farmers. It can be anyone in town who sees and we're all public.
No, fair enough, Commissioner Turner, because I remember when I first moved to Enfield and I built a shed that was too close to a non-disturbance area. The shed was beautiful, it was tucked in the trees beautifully in the corner right where I wanted it, but I had to move it because it was not in the right place. And certainly my fault, and I had to move it. Right. And that's one of those other things. I had to accept the consequences of doing it incorrectly. And I'm stuck here. I am stuck here.
And the thing is I'm looking, and I've gotten two sizes on this barn. It's either 210 feet by 32 feet, or it's 200.4 feet by 60.6 feet. And that is a lot of barn to try to move. Where?
It is 60 by 200.
Thank you. Because I saw two sets of numbers in all the documents, Lori. It is a huge struggle. And I have to go with your comments, Lori. It's more like ignore that the barn it was built, and what would we do on quote the variance?
Any other comments? Any other discussion? All right, I don't like the fact that the barn is sitting there, but we have to pretend that it's not. So with the understanding that if it's denied, he would have to move a barn or take down a barn, I'm not looking at, because to me, the barn doesn't exist. Our job as Zoning Board of Appeals right now with this application is to look at the possibility of granting a variance where the 100 feet is required, and we need to figure out what the hardship is. Is there a hardship that prevents him from coming into compliance or building a building in compliance with the regulation? Pretend the building doesn't exist. He didn't build it. If he came in front of us right now and said, look, I'd like to drop a barn 35 feet from the property line on Broadbrook Road, and this is why I can't go where it needs to go. Does he have a variance there that prohibits him from putting the barn where it needs to go? Now, I understand in the talking process of it, he was given wrong information, but he didn't follow the information. Had he followed the information, we wouldn't be having this discussion, because he would have followed bad information and, oh, well, we would have been stuck with it. That's not the case. He simply wants a variance to place a barn 35 feet from the property line. I personally don't see a hardship there. There's plenty of places on his property or properties to put a barn. It doesn't have to go right there. He's got the flattest, smoothest land there is over there. So, and I can't vote for it unless somebody can show me what a hardship would be for that barn. Why would we have to let somebody build that close if there's all these other options to them? And that's what we have to look at.
Mr. Chairman, in past decisions, we've also discussed changing the size of the structure to meet the requirement, the zoning requirements.
Right,
as well.
right. But I understand that, but remember, the building isn't there.
Right.
And keep saying that till the cows come home, no offense here, but there is a building there. And to take it down or push it back,
We don't look, we're not looking at a building.
right. But if you go to this, when you look at the photos, and there's one barn that's perpendicular to the road, and my guess is it's in that 40 or so feet.
But here's the, right. And you might have arguments to say.
Is there anything that would the hardship be that because there's a barn behind it, but then the question would have been, then just make the barn a little smaller.
Right, or turn the barn, or, something. The problem I have, and please, Lori, don't take any offense to this, because you have great ideas. But giving leeway to something will get thrown back at us. Because somebody else will come in front of us and say, yeah, but I have a beautiful building too. And I don't want to open a door, because it took us a while to close that door. Some of you on the Commissioner, Marianne, have been here for a while, because when we first started, we were seeing people come in and ask for forgiveness, not permission, all the time.
It was all the time.
It stopped. It went away. I don't want to open that door. And I don't want to get into a discussion of how beautiful it is or how difficult it would be to move. They moved Cape Hatteras, a lighthouse, away from the shore.
Mo, we've had buildings that have had to come into compliance.
Right. They can move anything. I don't care about the building. It doesn't exist.
Okay. Do you have any
So with that, I don't see a hardship. Anybody else have anything else?
I struggle with the hardship as well, given the amount of land that is there and the way the land is being used. And that's not meant to be judgmental. I respect what they've done with their property, but I don't know that the land has created the hardship in this scenario. To the applicant's own words, the barn has taken up land and they're using the space around it for hay and everything else.
Well, the thing is there, in retrospect, like all things, the variance would have been easier to handle. We would probably just made some requests. And I don't think there's anything else. I have nothing more to say.
Okay. Anybody else? Do I have a motion to approve?
Motion to approve ZBA 2021-03-23 at 69 Broadbrook Road for a variance to allow a 60 by 6 foot by 200.4 foot to encroach up to 65.9 feet into the 100-foot yard setback. Stephen Jarmuth, applicant, Jarmark Farms LLC, Jarmark Real Estate LLC, owner map 102, lot 49, R88 zone.
Do I have a second?
Second.
Roll call, please.
Mo La Rosa,
No.
Marianne Turner, no. Charles Masterbirdy,
No.
Kelly Davis,
Yes.
Rich Stroney.
No.
4 against, 1 for. It's 1-4-0. So it did not pass.
Thank you. I'm sorry, Mr. Jarmock, but your application was not successful. You can talk with the planning department and find out how to move forward from there.
Thanks so much.
We have one more application. Can I get the legal notice, please, when you get a moment?
I believe that one, there was a
Yep.
request to move that.
Right, I don't think we want to move forward. That one has been tabled
Okay. I
by the
didn't see that.
applicant. We received a letter this afternoon,
Oh,
Mr.
I haven't
Chairman,
looked at my emails.
from Attorney Donnelly and Attorney Landolina. They've asked us to consider this a formal request for a continuance for the above application of 128 Moody Road from tonight's meeting on behalf of the owner. A continuance is hereby requested for the application 210330. The continuance is necessary to allow for time to review documents produced by the town relation to an FOI request. Finally, at least part of the above appeal will focus on the legal interpretation of 3.30.13G small I in your regulations. In order to expedite the appeal, we respectfully request that the commission seek a legal opinion regarding the meaning of that regulation as it applies to this matter. Please let me know if you have any questions.
Okay, do I have a motion to accept?
So moved.
Second,
Second.
roll call?
Mola Rosa,
Yes.
Andrew Abanowitz.
Abstain.
Okay, I'm leaving you out. I'm gonna put Rich back in. Is that all right, Mr. Chairman?
Yes, ma'am.
Mary Ann Turner, yes. Charlie Masterbirdy,
Yes.
Kelly Davis,
Yes.
Rich Stroney.
Yes.
Okay, it's been tabled.
Okay. So, oh, where'd I put it? There it is. We all have, that's the last thing we had there.
We have
Moving to
minutes.
Number 7, minutes approval for March 22nd. Do I have a motion to approve?
So moved.
Made by Mary Ann. Do I have a second?
Second.
Rich Stroney, it sounded like.
Yes.
All right, discussion.
There were no, I didn't find any changes.
No discussion. Roll call, please.
Mola Rosa,
Yes.
Andrew Abanowitz,
Yes.
Mary Ann Turner, yes. Charlie Masterbirdy,
Yes.
Kelly Davis.
Yes.
Correspondent staff reports.
So this is Jen. We have a new assistant town planner in the planning office. Her name is Georgie Driver. I saw her on here earlier. I'm not sure if she's still on. If she wants to say hello. I don't have my participation list up, so I don't
Yeah, she's
see
on.
everyone.
She's on here.
Hi guys,
Hello there.
it's nice
You're
to meet
welcome.
you. I'm Georgie. Hope to be helping you guys out.
Glad to have you on board.
Where'd you come from, Georgie?
I used to work for the city of Salem, Massachusetts, and then I graduated school and I moved back to Connecticut. So it's good to be back in Connecticut for urban planning, and I have a master's degree in GIS, so I do a lot of mapping and I like to basically help people out. So
Well, welcome to the neighborhood.
thank you.
All right. Anything else?
We also have our POCD. We had a POCD meeting last week, and we have another one this week. That's a public forum. I don't know if Lori wants to speak more on that or not. I don't know.
I
But
don't
the
have
public
much.
is invited.
Yeah, the public is invited. Go to the planning webpage or the planning and zoning webpage. So you can either go to the commission or to the department web pages, and that's where all the links are. And the public is invited. It starts at 6:30. And it's basically to help us move Enfield into the future. Decide where we want to go with our plans.
All right.
So come one, come all. We'll try to make it work. At least platform wise.
All right. Anything else?
We also have new permitting software. I'm saying this out on the airwaves now because we've had some issues with applicants not creating actual accounts to access their comments from staff. And we are trying to shift all of that electronically. So if you're out there and you're listening, please make your accounts on Viewpoint Cloud. You'll be able to see your comments. And
Will,
other
will,
than
will you
that-
still have the paper version for those that might have technology issues?
Yes,
Challenge-
we do still have the paper versions. Oh, and before I forget, we were going to start the process of reviewing application forms again. So we're gonna take a look at the forms and try to update them a little bit, and we'll bring those before commissions for review as well. You know that ZBA particularly likes to see their forms.
Jen, as
Yep.
when I was, commissioners, when I was in last week signing off on the K7s, there is something that I noticed, that we have to be extremely careful what words we use when it comes to a K7. Okay, there's dealer, they're on the form. Jen, I don't know if you have one in front of you. Anyway, when we use language, which is what happened in one of the last K7s, the language got convoluted, in my opinion. The lawyer said it properly, but when you folks made your motion, you didn't quite make it the same, which then led me, when I'm standing there looking at it, going, I know what you meant, but that's not what you voted. And this will make a lot of sense. So I'm asking Jen that in the future, that the K7 boxes that have to be checked off either as a new change, dealer's license, what were the other ones? Do you remember?
Yes,
Used
the
car,
limited repairs versus
Limited-
general repairs.
limited repair, general repair, that we have that information right in front of us, and we use the right words when we do this project. So I've asked Jen to please put that in our stuff when she works on the application changes. And I'm also going to ask another one through the chairman. I want to start seeing what is a variance in our page. Jen, I don't care if you make it one, you know how you have to send me the motion sheet?
Yep.
Could you just please type up what is a variance so that it's in our packet every meeting, because we need to read that to the public before we start a meeting. And that it's been a last couple of meetings that we're winging it. And I just want us to, I think if you don't mind adding that to the packet.
Yeah, that can go into the staff report. That's probably the better place for it, right on top.
As long as it's always just plopped right in there, okay?
Yep.
Like a template, okay? Those are two things that I'd like to see.
Other than that, we have a request from our zoning tech. If you could please bring back your folders and your or your little envelopes from the packets and things. We're running a little low because we're sending out a lot of stuff, and people aren't necessarily coming back into town hall to drop them back off these days.
Putting it in that bucket in the front door works, right? That gets back to you all?
Yes. Yep.
Okay.
I don't know. That's it from me. I don't know, Lori, if you have anything else.
Nope, I'm good.
Are we gonna be back in the town hall anytime soon?
My guess would be, the earliest would be June, because I don't think that the governor's gonna lift most of the restrictions until late May. So, but I haven't heard specifically. That's just my supposition.
Okay. All right. If nobody has anything else, I'll entertain a motion to adjourn.
So moved.
We're adjourned.
Have a good night, everybody.
Have a good night.
Good night, everyone.
Right.